Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Mark Erickson, and Mark is a family law attorney whose firm is located in Campbell, California. He graduated with a JD or law degree from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. And after working for another attorney, mostly in the areas of civil and business litigation from 1979 through 1984, he founded his own law firm in 1985. Mark became a certified family law specialist by the Board of Legal Specialization of the State Bar of California in 1987. He has lectured and presented seminars for many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. And Mark's oldest son has followed in Dad's footsteps. He's now an attorney working in Mark's law firm. Today we're going to be talking about child and spousal support related to divorce in California. And this is a big enough topic, we decided we're going to stretch this into 2 shows. So if you miss one, we'll have them posted online. You go into financialinsiderweekly.com, past episodes, and you'll be able to find them there, as well as a lot of other interviews with Mark. And anyway, this is a complex area of law for which you should consult your own attorney. And be aware, divorce laws vary among the states. Mark, thanks for joining me today.
Thanks for having me.
Okay, here we go. Big subject here, I guess. You've got tons of questions you've written to yourself here. so anyway, we should be able to fill our time quite well. Why don't we start just with, what's the definition of spousal support, and then what's the definition of child support?
Okay, so spousal support is usually an amount of money paid monthly from one spouse or former spouse to the other. It's often a fixed amount, but sometimes it's a variable amount, and we'll get into that, into the specifics. It's usually tax deductible to the payor and taxable income to the recipient. It's something that is often requested at the outset of a dissolution of marriage action, requested by the lower earning spouse to be paid by the higher earning spouse. And as you can imagine, that can be a very difficult issue. As far as child support is money intended to make sure that a child or children have adequate support. It also is something that can be requested at the outset of a dissolution of marriage action. And for that matter, a lot of child support disputes arise between unmarried spouses in paternity cases. It's an amount paid from one parent to the other, usually based upon a formula, and it's normally either a fixed monthly amount or sometimes a fixed monthly amount with potential add-ons, including mandatory add-ons for uninsured health care expenses and child care expenses, and sometimes other add-ons where one parent may be paying money to the other as additional child support other than the basic child support.
Okay. So how has the child and spousal support issues changed over the years?
Well, one interesting change that I've seen, I started in 1979, and back in the early days of my practice, I never saw the woman or the wife or ex-wife or mother paying child or spousal support to the other parent. It was many years before I saw that occurring, and now it's very common. In fact, with younger folks, I would say in my practice, it's probably close to 50-50 that the wife or mother is as likely to be the payor as the husband or father in both child and spousal support. So that's been one significant development. In terms of the law, when I first started practicing, we didn't have the mandatory child support calculation law that currently exists. It's been around a long time now, but when I first started practicing, each county had a little chart with suggestions on what the appropriate child support should be. And now we have sophisticated software that helps a court determine mandatory child support under a state-mandated formula. The same support software is often used to prepare calculations of temporary spousal support, can't be used for permanent spousal support. We'll talk about that. So that's been a big development, is the use of software to give, I'll say, greater certainty or predictability of the results.
Right. Now, one thing that I'll mention is that in the old days, we always saw it in the movies, right? We were talking about alimony, and so nowadays we softened it to spousal support, I guess.
Yeah, that's what we call it in California.
Okay. Okay. So how does one apply for child or spousal support?
Okay, so usually somebody's going to file something with the court, and I'll focus on a dissolution of marriage, or it could be a paternity case where somebody files a complaint to establish paternity. But for child support, it involves filing a motion, which we now call an RFO, request for order. It typically would be filed at the beginning of the case. The same would be true for spousal support. So normally what we would see is when somebody first files a petition for dissolution of marriage, at that time the lower earner would likely be filing an RFO asking the court to set support. And this is a fairly simple form with a factual declaration that gives the court some background about the length of the marriage, names and ages of children, financial circumstances, and sometimes a lot more information about education, background, and ability to earn, particularly if somebody is unemployed or underemployed. And you also file what's called an income and expense declaration, which is on a pre-printed form where you disclose exactly that income and expenses and some minimal information about the value of your property and existence of property, which can be important. The forms, in an easy case where you have either somebody that's not working or somebody that has a fixed salary, it's fairly easy to prepare. Sometimes it's a lot more complicated in the case of self-employed people, people that work for commissions like a real estate broker, people with variable incomes. That sometimes takes a lot more work and might require the services of a forensic accountant to assist.
Wow.
And so when you file those papers, normally the first hearing will come up in the ordinary course, maybe 5 or 6 weeks out. And in most cases, people are able to agree on what the support order should be before that first hearing, because we have the support software that helps lawyers and clients determine what the likely result would be if they didn't agree and the judge had to make a decision.
Okay. So maybe you can tell us a little bit, what's the difference between temporary and permanent support, and how long does a temporary spousal support order last?
I can't tell you how many times people ask me, how long does temporary support last? So temporary support is intended, certainly in the area of spousal support, to maintain some sort of status quo so each party can exist. It's often not as sophisticated as the analysis in a permanent support order, but it hopefully puts each spouse in a position to at least meet their basic expenses. The same with temporary child support. The system is set up so that these decisions could be made fairly quickly. 6 weeks might not sound like a short time, but that's reasonably quickly. And these are often set on calendars where the court has many hearings at the same time. So you might show up in court at 9 o'clock and there might be 10 or 15 cases many of which are temporary child and spousal support cases, so the judge only has 15 or 20 minutes per case. So they need some efficiency, and they count on, probably most people are going to reach agreements before the judge has to have a hearing to make a decision, and so the software is helpful in doing that. How long does it last? I've seen temporary orders last for more than a decade, just because people chose not to pursue their cases and move them along. I would say typically the average case I would see from the time somebody files a petition to dissolution of marriage until they get a judgment, I'd say 12 to 18 months is very common. And so during that time, until you have what we would call a judgment or a permanent child and spousal support, it's called temporary. And there are somewhat different rules on temporary support as opposed to permanent support, particularly when it comes to spousal support. But there's nothing preventing people from having a very long-term temporary order.
You wonder, is this so temporary? Well, what about temporary child support? Is it the same sort of a situation, or?
Same sort of situation, and of course, child support, we know that there will be an absolute termination date when a child turns 18 or 19 if they're a full-time high school student living at home, unless they're a developmentally disabled child or if the parents agreed to some longer duration. And the rules for setting temporary child support and permanent or judgment spousal support or post-judgment, child support are essentially the same. The mandatory formula mandated by the state that tells us how we calculate child support is going to be in effect at the beginning for temporary support as well as later post-judgment. In terms of spousal support, the rules change a bit because when you're setting judgment or permanent support, the court has to look at a lot more factors than they would at the beginning of the case setting a temporary spousal support order.
Okay. So how long does it usually take to get this temporary order for either the spousal or child support?
Usually, well, sometimes if there's cooperation, almost immediately, if people share income information and sit down and negotiate without going to court. As I said, if you go to court, probably 5 or 6 weeks would be typical, but sometimes that gets delayed. That's for cases that can be heard within 20 minutes or so. Sometimes people have much more complicated disputes, primarily because of disagreements on income, or we'll cover a bit of this later in this session. How do you deal with disputes where one person isn't working and you think they should be working? And sometimes those hearings take hours or days.
Oh dear, okay. So do you have to go before a judge in order to get this order?
No, and as I said, I think most people, I would say 90% of the time, we reach an agreement on temporary support without appearing before the judge. It may be negotiated at the courthouse when you're supposed to be there for the hearing, but it's resolved out in the hallway, and then the judge is just informed of the agreement and signs off on it.
Okay. So are there separate judgments for terminating the marriage and for financial issues like spousal support and dividing property?
There can be, and we call it bifurcation. So the law provides that you can have multiple judgments that are final on various issues. One of the most common is terminating the marriage. The law provides that you can terminate marital status 6 months after the respondent is served with a petition for dissolution of marriage. And very often one party, or sometimes both of them, want to terminate their marriage so they can remarry or file taxes differently. And they need to do that or want to do that before the other issues have been resolved. So that's common. Spousal support is often, more often than a lot of issues, a disputed issue that may require a trial, probably more often than some other issues. And so that might have a separate trial and a separate judgment. Some issues often are resolved quickly up front, and for example, some simple property issues or division of a pension is often very commonly done separately and early on. So you may have 4 or 5 judgments or separate orders, although typically I think most people end up with one final judgment.
Okay. How does a court determine whether a spouse or former spouse qualifies for spousal support?
Okay, well, in terms of temporary support, you're usually looking at income differential. So it'd be very easy if, say, one spouse is a highly compensated engineer at a local high-tech company, and they're making $200,000 a year, plus stock options and restricted stock units and bonuses and other increments of income, and the other spouse is unemployed. That's an easy one. There's no question there's going to be, that person's going to qualify for temporary support. When you get to permanent or judgment support, the court's required to look at a whole list of factors in a family code section, which includes length of the marriage, and that's a big factor. The length of the marriage can be very influential on how long a spousal support order is going to last. The law says that 10 years is presumed to be a long marriage, and after a long marriage, the court should not set a termination date unless there's evidence that the supported spouse will be self-supporting by that date. So length of marriage is a big factor. Age of the parties, certainly a big factor. You see a lot of divorces with people in their 50s or late 50s approaching retirement age, and there's going to be a big question about whether a payor is going to be required to continue to pay spousal support after they retire. We also see, because of age, particularly it seems like in the high-tech area, I see a lot of age discrimination, and so you see a lot of folks in their 40s and 50s that have difficulty finding a good job even though they have a history of high income. You see a lot of long-term unemployment. Those cases are very difficult. Let's see what else we have. The education of the parties, do they have college degrees? Are they making use of their degrees? What's their experience in the workforce? Has a parent stayed out of the workforce to raise minor children during the marriage? Are there separate property holdings of one spouse or the other that might produce income or affect their ability to pay or need for support? The court's also required to look at whether there is a history of domestic violence as a factor for consideration. I've probably forgotten a couple of the considerations. There's a catch-all. Anything else the court thinks is important or relevant to consider. So the court is supposed to look at all of these factors and then come up with an appropriate amount and duration of spousal support. And I always tell people that what that means is if we had 100 different judges look at the same facts and hear the same evidence, they might make 100 different orders, all of which would be within the bounds of their discretion. So permanent spousal support is often difficult to predict what the outcome will be, which means there tends to be more litigation in that area than, say, child support, which is more predictable.
Okay. So you've got more tidy things that are going on for child support, but I mean, one of the things, considerations, of course, is whether a former spouse, maybe they haven't been working, but now they're going to be starting to work or something like that, and so suddenly they're providing support for themselves.
That's a huge issue, and that's where we see a lot of expense and a lot of difficulties in divorce. It's very common when the divorce comes that one person isn't working, or even more difficult, neither of them are working. Sometimes by choice. You see folks that they've been high earners and they drop out because they are involved in a startup. So they're investing their time for some future payoff in some high-tech project that may or may not pay off years down the road. those cases are difficult.
Yeah.
The law tells us that the court can set support based on imputed income, meaning you assume somebody is making income they're not making in determining support. And the criteria for that is the other spouse has the burden of showing that that spouse has the ability, what is their ability to earn, and the availability of jobs that they're qualified for. And that can be difficult and sometimes requires expert witnesses, such as a vocational consultant, who will evaluate the unemployed or underemployed spouse to determine what are they capable of doing, match them up with the job market. And so we see cases where maybe somebody quit work right before the divorce started, or very common, one spouse stayed home and homeschooled children, or was a stay-at-home mom, and now the divorce comes and they're told they have to go out to work. And that's very difficult because a lot of people just aren't prepared for that. It was not in the plan, and those situations can be very difficult for both the payor of support as well as the recipient.
Yeah. Well, when you're dealing with this imputed income type situation that you're talking about, I mean, it all sounds well and good, but if they're not getting cash, how the heck are they going to pay it?
Oh yeah, it's very difficult, and it's often time consuming because the court rarely is going to impute income immediately at the outset of the case. So it often involves multiple returns to court, perhaps expert testimony, and usually starting out with an employment efforts order, what we call a seek work order, where the judge actually makes an order that tells somebody they must apply for so many jobs and periodically report to their spouse or their spouse's attorney in writing that shows what efforts they're making, and then there can be hearings about whether they've actually fulfilled their obligations. Are they really making a good faith effort? And if they're not, that puts the court in a position of considering the imputation of income.
Okay. So we talked a little bit about amounts. What about how long these things last, or the duration? So how's the duration of child support determined?
Okay, well, child support's fairly easy because by statute it tells us age 18. Child support ends at age 18 unless a child is still a high school student full-time, then it can go to age 19. So you can just look at the birth date, and are they still in, when do they graduate from high school, so you know when it's going to terminate. Spousal support, you don't always know. Now, in a short marriage, say it's a 2 or 3 year marriage, you're probably going to have a very short spousal support order. Certainly in a shorter marriage, the old rule of thumb of half the length of the marriage is often applied, particularly in a settlement. So if you had a 4-year marriage, it wouldn't be unusual for people to agree to a spousal support order that lasted for 2 years and then terminated. In over a 10-year marriage, now you're in an area where it may be difficult to negotiate an absolute finite duration where the spousal support order is going to end absolutely at a particular point.
Okay. So what happens if a spouse is awarded the spousal support, but then that person remarries?
Okay, well, by law, spousal support terminates on the recipient's death or remarriage. So it is automatic, although we do see cases where people remarry and don't tell the payor, in which case they're going to have to repay the support. I also have seen a number of times where people have a commitment ceremony where people show up thinking the folks are getting married, but they don't have a license or don't follow through in the formalities, so technically they're not married, which may be a device to try and prolong spousal support payments from a former spouse. You can imagine how the payor might feel about that.
Yeah.
There's also a provision in the law that there is a presumption of decreased need when there's cohabitation So if someone, a recipient, is living with a new partner as if they're in a marital relationship, that can be grounds to at least reduce, if not possibly terminate, spousal support.
Okay.
There's a lot of litigation in that area, as you might imagine, that cohabitation is often disputed. The payor thinks that their former spouse is living with their boyfriend, girlfriend, or partner, and that person is in denial, and sometimes it's difficult to prove. People can go to great lengths to hide it.
So then you hire a private investigator, I guess.
People do. Sometimes they do, yes.
Okay, well, gee, we only have about a minute left, so maybe you can throw out a final thought here, and then we'll figure out where we're going to pick this up for our next interview.
I guess the final thought would be, if you're the payor of spousal support, what I've found over the years is, unfortunately, it's probably best practice to be aggressive in your position and try and push your former spouse or soon-to-be former spouse to be working as soon as possible at their maximum capacity. The old saying, good guys finish last, is often true in the area of spousal support. You often don't benefit by trying to be a nice guy or a nice woman to your former spouse. It's better to aggressively pursue it, and for a recipient, it's probably in your own interest to try and be self-supporting, because there's always a risk when you're being supported by someone else.
Okay, we're out of time, Mark. Thanks for joining me.
Thank you.
Folks, we'll see you next time on Financial Insider Weekly.